Hello everyone and welcome back. It is Law by Reese here with another video following the Young Thug or YSL trial. Before I get into it, guys, I want to ask that you like, comment, and subscribe. And if you want to support me in a big way, support this content, there are donation links, CashApp, Venmo, and then Buymeacoffee, where you can pitch in $5, $10, whatever you can afford. And that really helps me out, guys, in terms of making new content and new videos. Unfortunately, in this world, you need money to operate. So in order for me to do well at YouTube, I've got to make income from it. So any donations are appreciated. Okay, guys, with that being said, before I get into it, I first want to give a big thanks here to Thugger Daily, which is an X account that tweets out daily or follows the trial. So I follow this Thugger Daily. And then I also want to give a big shout out here to Cat Not Williams. I'm pretty much doing largely the same thing that she does, but she links to the filings, and that's really appreciated because as a Texas attorney, I do have access to Texas e-file, and I'm sure that I could find these filings publicly, but I'd have to pay for them. So just getting them for free and having them presented is really a nice thing. And then I appreciate Cat Not Williams' commentary, so make sure to go check out her channel, guys. I don't want to, basically I want to make sure that she gets all the love and support as well. Okay, guys, so before I get into the three motions that I wanted to discuss today, I want to go through some of these posts here by Thugger Daily, starting with the latest ones, guys. It is Monday, July the 29th, 2024. Okay, guys, so from 3 hours ago, 3 filings from the state in the YSL, which I have today. Firstly, of the 4 pending mistrial motions, the state has chosen to only respond to Bruce Harvey's motion on behalf of defendant Nichols. They say there's no issue with the judge coming in 9 months into trial. I'm sure that's true. For those asking about the response deadline being broken, these were filed Friday at 11 p.m., so they meet the deadline but just didn't become accessible to me today. And then we have full documents here. I'm going to double check this to make sure that we have all the motions that I want to talk about today. I've got 3 I'm going to talk about, and then I'll check at the end of the video. As pointed out by this reply, the motion to compel actually did meet the judge's Thursday deadline for new motions, and I don't see a good reason for that. Let me tell you guys, so I am an attorney here in the state of Texas, and dealing with timeliness motions, especially in civil practice, can be a big deal. So for example, there's a couple different things when you get into civil litigation. Now, this is criminal litigation or a criminal case, but I'm just coming at it from a civil background. And usually things that are filed a few hours or a day late, that timeliness is usually going to be waived. Although sometimes if it's repeated untimeliness, the judge might decide, hey, you know what, too bad, that motion or that response is not going to be considered. So when you file something untimely, and if it violates a rule of civil procedure and there's no agreement between the parties to file something untimely, or if you don't have an extension, the judge, that you can object on timeliness grounds or on procedural grounds, and then the substance of that motion or that response might not be heard. So it is a big deal in your court cases, whether they're civil cases or criminal cases, that your lawyers are filing things timely. Because if you don't get a Rule 11, and in Georgia it might be called something else, but if you don't get an agreement to extend a deadline, or if you don't get a good cause shown by the judge, that the entire thing can just be tossed out, and that filing not considered as a part of the record. So there can be serious consequences for not filing something timely, but usually that is up to the discretion of the judge. So I can't comment on whether that would automatically be thrown out or not or something like that, because it's really usually up to the court's discretion. Okay, guys, so there are 3 responses that I want to get through, and I'm going to basically go through the full length of these motions, and I'm going to give you my commentary. Now, guys, quick disclaimer that I'm going to give in pretty much every video. I am not a Georgia licensed attorney. I am a Texas licensed attorney. And although I do engage in criminal defense, I was only licensed about 2 years ago. So I'm not a board certified criminal defense attorney. I am a criminal defense attorney, just not board certified. I've also have significant time since I've been licensed in civil practice. So again, I might approach this from a more civil perspective, even though it's a criminal case. And also, guys, I am not a Georgia licensed attorney. I'm only licensed in Texas. So my commentary, you should be taken with that in mind. Okay, guys, so starting with our first filing, we have in the Superior Court of Fulton County, Georgia, and we can see this was filed on July 26 at 11:57 p.m. So in case you're not familiar with the legal world, there are two different ways of phrasing a deadline, and that is end of business, which usually means 5 o'clock, or if it's just that day. So let's say that there's a Friday deadline, you can file all the way up on Friday up until 11:59 p.m. And if that file stamp reads 11:57, 3 minutes before the next day, it is timely filed. And you might be asking yourself, like, how often does this really happen all the time where lawyers are filing things literally 3 minutes before the deadline? And as someone who's only been out for 2 years since passing the bar, I can tell you that, in fact, it happens all the time. All the time, guys, especially Friday deadlines, and attorneys love to file things last second. So this is pretty common for things to get filed at the very last second. Now, you can imagine sometimes when you have there's an error or there's a glitch or the e-filing system is down, and then you might have to actually run it up to the courthouse before 5 p.m., before the courthouse closes. So they can just be glad that their internet was working. Like, guys, the judge is not going to care too much if your internet wasn't working. You file something the last second. So I see this all the time, but yes, there can be consequences to filing things untimely. But you will oftentimes see things get filed the absolute last second. Okay, so filed July 26, 11:57. July 26 was last Friday. Today is Monday, July the 29th, as I'm making this video. Okay, guys, so we see State of Georgia v. Quamarvius Nichols et al., defendants. Judge Paige Reese Whitaker, case number 22 SC 183572. We start with the title here. Response in opposition to defendant Nichols' motions for mistrial and severance. So I'm going to hold your hand here, and I understand that there are some people that are already familiar with this, and I apologize if you are already familiar with this, but a motion is where you're asking the judge to do something, so you are moving the court, and the court is a euphemism for the judge. So, judge, I'm moving you. I'm trying to persuade you. Please give me what I want. I'm moving the court, and that's what a motion is. So you're literally taking the judge in equipoise and trying to move her. You're trying to move her into your side. So that's what a motion is. And then what is a mistrial? A mistrial is basically there was a hung jury, or there was some filing or procedural mishap that so severely violated the defendant's constitutional rights or was so severely botched that a fair and impartial trial cannot be held. Now, you can have a mistrial with or without prejudice. So with prejudice or with jeopardy attaching, and I believe that's the Sixth Amendment to the U.S. Constitution. When you have a mistrial with jeopardy attaching, the state would be prevented from refiling the case. That is basically as good as an acquittal. Okay, it's not quite an acquittal, but it's not the same thing as an acquittal, but it is as close as you're going to get to an acquittal, and it is the absolute best outcome that these defendants can have, because a mistrial with prejudice means that on these RICO charges, these defendants cannot be retried. And I believe that would also include any of the lesser includeds that arise out of this trial, or out of the RICO case. So my point being is that a mistrial, without even your clients getting off without even having to go to the jury, would, for obvious reasons, be the best result for the defense. Okay, and then severance. Severance meaning that you either want to sever your case from the other defendants' cases, or there's some aspect, or in a criminal case, there might be some charge that you believe or you're arguing should be severed from the remaining charges and tried separately. And so that's what severance is. In a civil context, it's usually a cause of action. So, for example, you might have a breach of contract suit and a personal injury suit arising out of the same car crash, and for whatever reason, they want to try the breach of contract suit or let's say the insurance fraud, the 541 claim, and that claim is, separate and independent from the underlying claim, and so you might move to sever those two causes. So that's what severance is. It's taking two causes of action, or in this case, criminal charges, or two different defendants, and severing them into separate trials. Okay. The state of Georgia hereby moves this honorable court to deny defendant Nichols' motions for mistrial and responds in opposition to defendant's objection to trial judge substitution. In support of this motion, the state shows this honorable court as follows. And that should be a colon, not a period. Okay, cap Roman 1. So in case y'all are not familiar with how I say this, if this is a Roman 1, and this is going to be your first heading, and then this is cap A. So you'll see me say Roman 1, cap A, Roman 1, cap B. All right, Roman 1, introduction, cap A, as in capital A. The mid-trial substitution of a judge does not violate the 6th or 14th Amendment rights to a trial by jury. So we're going to get into the first argument here on why the state believes that the mid-trial substitution of a judge does not violate the 6th or 14th Amendment rights to defendant Nichols' trial by jury. In paragraph 1, defendant Nichols asserts the mid-trial substitution of the trial judge violates his 6th and 14th Amendment rights. The mid-trial substitution of a judge does not violate the 6th Amendment or 14th Amendment rights. This claim was made in McIntyre v. State, and that's a 1995 Georgia case, and the Supreme Court of Georgia, quote, assumed for purposes of this appeal only that these rights are implicated by the mid-trial substitution of judges. Now, depending on my audience, I think there are going to be some audience members that don't know what implicated means. So when the court here in this 1995 case said assumed for purposes of this appeal only, that means that, all right, we're going to stipulate only for these set of facts, and then that these rights are implicated. And implicated basically means brought up or mentioned or remarked upon. Okay? That these rights are implicated by the mid-trial substitution of judges, and ultimately rejected that claim. However, when it did so, the court specifically referenced People v. Espinoza, 838 Pacific 2nd, 204, 12A. It's a California case from 1992, in which the Supreme Court of California held that a mid-trial substitution of judges does not violate those rights. So normally, if you are in a Georgia case, you're not going to cite a California case. But if your Georgia case, in that opinion written by the Georgia court, if the Georgia court is citing to a California case, then it's more reasonable to go ahead and look back at the original cited case. Okay, so in normal cases, if you're reading a Georgia case, you're not going to see citations or references to a California case. But because in that particular opinion, the Georgia court referenced a California case, that's why you see that mentioned here. Okay, Cap B, concerns with directed verdict motions are unfounded. So let me first comment on Roman 1, Cap A. Your Sixth Amendment right is, let's go through that. Sixth Amendment to U.S. Constitution. U.S. Constitution, Sixth Amendment. All right, guys, so you'll find that, by the way, the U.S. Constitution is actually pretty short. But Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, and that's the confrontation clause, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So this is where you get court-appointed counsel. Miranda v. Arizona is the big case on the Sixth Amendment on the compulsory assistance of counsel. And then to be confronted with the witnesses against him, the case that you're looking for there is Strickland v. Washington on the confrontation clause. And then there's always your right to a speedy trial, which has been incorporated many different ways, but basically a speedy trial can be years. I think there's a huge Sixth Amendment issue with speedy trials right now. But anyways, let's go back. And then let's get to the 14th Amendment. All right, so I'm now going to move us to the 14th Amendment so that you're familiar with 14th Amendment, Section 1. You can see these, it's pretty short. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. Okay, and then you can see Section 5 is the Congress shall have power to enforce by appropriate legislation the provisions of this article. So, guys, usually when you're talking about criminal cases, it's going to be the 14th Amendment, Section 1, which is due process. So you shall not be deprive any person of life, liberty, or property without due process of law. Okay? So, Cap B, we go back to the motion. So, if you're wondering, Defendant Nichols is basically arguing under two provisions of the U.S. Constitution, under Article 6 and Article 12 of the U.S. Constitution, which is your equal protection. That's the 14th Amendment, and the Sixth Amendment, which, again, we go back to the Sixth Amendment. Sixth Amendment of the Constitution is speedy trial, to be informed of the nature and cause of the accusation, to be confronted with the witnesses. So we have a speedy and public trial. We have the confrontation clause, compulsory process for obtaining witnesses in his favor, which is due process, and to have the assistance of counsel. So, again, Defendant Nichols is arguing that either his 6th or 14th Amendment rights for due process have been violated by substituting a new judge in the middle of the trial. So now you have some background on that. Cap B, concerns with directed verdict motions are unfounded. In paragraph 2, Defendant Nichols asserts the mid-trial substitution is inappropriate because he claims it will affect his ability to request a directed verdict at the conclusion of the state's case in chief. This concern is unfounded. So, this is fairly good, just to comment on this, this is fairly good legal writing. In legal writing, setting up the other side's argument and then saying this is unfounded, this is baseless, and then explaining why it's meritless, that's a pretty common method of legal writing, and I'm not surprised that I see it here. A directed verdict of acquittal is only available if the evidence is insufficient as a matter of law. And then we see C. Boyd v. State. Now, just so you know, guys, this should also be italicized or underlined. So a little bit of a citation mistake there. Italicized or underlined. C. Boyd v. State, Volume 306, Georgia, 204 at 212, 2019. Okay, then we see a string cite to the statute. Now, just so you know, the District Attorney's Office here in Fulton County, Georgia, is not doing its Blue Book citations. And I know that that doesn't mean anything to the vast majority of you, but basically, do you see how this is a statute, OCGA Section 1791 sub A? The statute comes before the case that you're citing. So you always put, in order of citations, you always start with the statute, and then this C should be italicized or underlined. To overcome a motion for directed verdict, the state would direct the court's attention to admitted evidence which establishes the elements of guilt. So, I don't, this paragraph is fine, but a directed verdict, you're going to ask for a directed verdict always as just a matter of your strategy. You are very, 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 very unlikely to be awarded a directed verdict at the conclusion of a trial. Once the judge has heard all of the evidence and the case in chief from both the prosecution and the defense, and the jury has already been impaneled there for almost 2 years, the judge is going to be highly reticent to take away the jury's power and direct an acquittal. That is just virtually impossible. But still, as trial counsel, you need to move for directed verdicts. I mean, it's just one. If there's a 3% chance that your client can get off on a directed verdict before it gets to a jury, and a jury could do anything, you're going to ask for a directed verdict. So, anyways, Cap C, issues with familiarity. In paragraphs 3, 4, and 6, Defendant Nichols asserts the court advised the parties that she was unfamiliar with the previous trial proceedings, and this would affect the court's ability to rule on motions and objections. In paragraph 5, Defendant Nichols asserts the court's level of familiarity violates his due process rights. Defendant Nichols's claims turn upon this court's familiarity with this case. Among those jurisdictions which have statutes regarding the mid-trial substitution, before I get into this, guys, I do want to mention that the judge, I watched a video on it, the judge did in fact say that she was not keeping up with the case. So that assertion is based in the fact that the judge did in fact say that. Among those jurisdictions which have statutes regarding the mid-trial substitution of the trial judge, some require the new judge to certify their familiarity with the record. So this should be a him or her, not a plural. See, for example, Federal Rule Criminal Procedure 25A. And then so we have a citation to the Federal Rules of Criminal Procedure in a Georgia case. Quote, the judge completing the trial certifies familiarity with the trial record. And then we have Massachusetts Criminal Procedure Rule 38. Again, we're citing to notice that the DA's office here is spending an entire paragraph citing things that are not from Georgia. So just a sort of comparative analysis of the different jurisdictions. I don't know how persuasive that is, but all right. Massachusetts Criminal Procedure Rule 38, quote, any other judge of that court or properly assigned to that court, upon certifying in writing that he has familiarized himself with the record of the trial, may proceed and finish the trial. And then there should be a period there in the quotations. All right, then we have footnote number 1. Footnote number 1 reads, such statutes refer simply to familiarity. The state is unaware of any such statute which requires a judicial officer to read the entire record, as suggested by Defendant Nichols. Some jurisdictions with such statutes do not impose such a requirement. See People v. Cohen, 236 Pacific 3rd. It's a California 2010 case, noting that California Penal Code Section 1053, quote, imposes no requirement that a substitute judge certify his or her familiarity with the record, and thus authorities from other jurisdictions that do are inapplicable. Georgia does not have such a statute. Georgia's primary case is McIntyre v. State, 266 Georgia 7. I guess that 2 is at page 2, 1995. While one concurring justice opined that she, quote, would have the replacement judge scrupulously review the prior proceedings and state on the record his or her familiarity therewith so as to establish that the replacement judge is fully prepared to render informed rulings on any matters that might arise and to instruct the jury thoroughly. And that's it at 12. There is no authority requiring that within Georgia law. The majority opinion itself in McIntyre leaves the matter to harmless error review. Regarding the constitutional aspect of Defendant Nichols's claims, the Supreme Courts of other states which have considered this issue have determined that the mid-trial substitution of a judge does not violate the defendant's constitutional due process rights. Okay, so here we see a string of cites from California, we see a citation from New York, and we see a citation from Massachusetts. Neither the Constitution of the United States nor the Declaration of Rights demands more, and that's from the Massachusetts 1996 case. Notably, both states with and without requirements that the replacing judge certify familiarity have denied such claims. All right, so the basic argument is from the state is that, look, Georgia doesn't have a statute requiring that the judge certify her familiarity with the case. And furthermore, even though Georgia doesn't have that statute, it should be subject to harmless error review, meaning that if this decision were to go up on appeal, that it should only be reviewed by a harmless error standard, which is the state's preferred standard of review, obviously, harmless error. Harmless error review, what that means is that, okay, maybe some error was committed here, but for that error, would the conviction, would the defendant not have been convicted, or would there have been a different outcome? So did that error have a material outcome, impact on the outcome of the case? That's harmless error review. The reason why the state wants that standard of review is it's the easiest standard for the state to review, for the state on appellate review. So the state is always going to argue for harmless error review. Part of defendant Nichols' argument is that the court would not have personal or direct observations of prior proceedings, meaning that Judge Whitaker wasn't physically there. If defendant Nichols' arguments about personal direct observations were correct, then no mid-trial replacement could ever be permitted. So that, the state is arguing from a perspective that, all right, if let's say defendant Nichols' constitutional rights are violated by this mid-trial substitution, and the judge sets that precedent, then there is now precedent that all mid-trial judicial substitutions are grounds for mistrial or grounds for a constitutional right violation, and that would set a bad, or not a bad, but an untenable precedent. Okay, so if you are not from the United States, if you are from outside the United States is based on English. We have a system based on English common law, based on precedent. So oftentimes in these motions, when you want a particular outcome or you don't want a particular outcome, you might make a policy argument such as, if the court were to allow this outcome in this instance, look at all of the ramifications of that in case precedent. Okay, so that's an argument from the state that personally I understand, and I would make the same argument. The state sees no reason to believe that this very capable court, now I'm going to read that back. The state sees no reason to believe that this very capable court. So that's kind of flattery, the court meaning Judge Whitaker, and Judge Whitaker reading these motions, this very capable court. I don't know. If it were me and I were a judge and I read stuff like that, I would just disregard it. I don't like it. Very capable court. Maybe competent court, but very capable. I mean, are we just trying to blow some smoke? I don't know. I particularly think it's a little bit patronizing. Is unable to rule appropriately on motions or objections moving forward. So again, the state sees no reason to believe that this very capable court is unable to rule appropriately on motions or objections moving forward. Indeed, given how easily available recordings of this trial's proceedings are, the defendants in this case are better off in some respects than defendants in other substitution cases would be, as the parties can and have cited to timestamps of relevant portions of such recordings in making their arguments. Further, even though Georgia does not have a requirement that the court certify familiarity with the record, the state offers to do whatever it is within its power to do to assist the court in gaining appropriate familiarity. So let's give a little bit of flattery and let's say, okay, Judge, we'll give you whatever recordings you want, which I don't think the flattery is very persuasive, but the state making available any recordings the judge wants, I suppose that is somewhat persuasive. Okay, I'm going to take a quick pause here, guys. You're going to see a cut in this video, and then we'll continue momentarily. Welcome back, guys. After that break, we are on Cap D. Cap D, the temporary recess of the trial is not a basis for a mistrial. In paragraph 7, Defendant Nichols moves for a mistrial given the month-long recess in the proceedings. Defendant Nichols cites no law in support of that claim. Okay. Before I move on, I need to address that sentence. All right, this is just commentary from an attorney. I'm not a Georgia attorney, but I'm still going to comment on this. Defendant Nichols cites no law in support of that claim. Contrary to what might be popular belief, you do not need to cite law in your motions. Number one, you can cite to facts, or number two, then this is what the Texas law, the Texas code reads in both the civil practice and in criminal practice. You can argue for a reasonable change in the law. In other words, you can argue against a law, or you can argue in the favor of a law being changed or revoked. So in other words, you can argue in good faith that a modification of existing law is warranted. An attorney is allowed to make an argument that is not strictly based on case law. It might be based on the facts and the circumstances of the case, or it might be based on an argument for policy change or an existing modification of the law. In addition to that, the courts are to presume that all filings are made in good faith. So when the DA's office here says Defendant Nichols cites no law in support of that claim, in my opinion, that is somewhat persuasive, but not as persuasive as a non-attorney might think. You do not need to cite law for every sentence of your motion. You can cite to your case-specific facts, or you can argue for a modification of the law, and you are still making a good faith argument. All right, so attorneys oftentimes do go into politics and into policy-making matters because you get so used to making policy-based arguments. All right, Defendant Nichols cites no law in support of that claim. As I just told you before, you don't need to cite law in all of your claims. You can try and defend your client based on the facts, or you can argue for a modification of the law. You can make those arguments in good faith in your filings. Indeed, a month-long recess, though unusual, is not unprecedented. See State v. Campbell, 851 Southeast 2nd. Oh, what a terrible, didn't underline your C, didn't italicize your C, and didn't do South period, E period. You can tell this motion was not passed around enough at the office. See State v. Campbell, 851 Southeast 2nd, 691, North Carolina Appellate 2020. A month-long recess occurred during jury deliberations when a juror was in a car accident. That's not a Georgia precedent. State v. Antoine, 774, Southern 2nd, 353, Louisiana Appellate 2000. Defense counsel's illness prompted 2-month recess. Also not, that is also not a Georgia precedent. And then Corona v. State, 2022, Texas Appellate, Lexus 7895. So they're looking all over the place in their Lexus and Westlaw. Well, look, they bounced in 3 different states. They went from North Carolina precedent to Louisiana precedent. And then you've always got to be careful, guys. I'm sorry. You got to be careful when citing Louisiana precedent. And then they cited Texas precedent. And here, unpublished opinion. Recess based on defendant's hospitalization lasted more than 1 month. By the way, if they're going to cite Texas law, they should do a proper Texas citation, and so this should include which Texas appellate circuit it was in. Just saying. So is not unprecedented. So listen to this sentence. Indeed, a month-long recess, though unusual, is not unprecedented. And then look at the district attorney's citations. It's North Carolina, Louisiana, and Texas. So when you're a judge reading that, and you're in a Georgia state case, and you've got 3 citations from admittedly similar jurisdictions, we're all southern jurisdictions, but none of that is Georgia precedent. So, in fact, it might actually be unprecedented in Georgia, which is where the jurisdiction is. So it's where you're taking this statement is not unprecedented. Is that true? Yeah, it's true in Texas, Louisiana, and North Carolina, but it actually is unprecedented to my knowledge in Georgia. Or believe me, they would have used a Georgia precedent. So when you get into the nuance of things, and I love reading case law because you can sort of, from an attorney's mind, you can see what's going on behind the scenes. When they say it's not unprecedented, and if you're not an attorney, you have no training in this, I understand, like, oh, what does that mean? Well, what I'm saying is that it is actually probably unprecedented in Georgia, because if it were not unprecedented in Georgia, they would have cited a binding case. They would have cited to a Georgia case. So the district attorney's office is basically admitting that the district attorney's office didn't have a Georgia precedent, and the reason why this case has gone on so long, which in my opinion does violate the Sixth Amendment right to a speedy trial. It's just my opinion. But basically, the district attorney's office is partly at fault for why this case has gone on so long. And they're somewhat like open-handed, like, hey, don't notice that it's kind of our fault. It's kind of the DA's office fault that this trial has gone on so long. Here's a case from Texas, Louisiana, and North Carolina. But it might be unprecedented in Georgia where our case is. So if it's just something that if you're not an attorney, you might not notice, but I think that it should be brought up to the public's attention. Cap E, the court should again deny the request for severance. In paragraph 8, defendant Nichols again moves for severance based on alleged, quote, spillover. This court should again deny that motion. It is well established in Georgia. Now, see, notice that when they have Georgia case law, they're citing the Georgia case law, but where they have an argument that they don't have a Georgia criminal precedent, it's Texas, North Carolina, Louisiana. But we come back to our next argument and notice now we're citing to binding Georgia authorities. So it's just something that I would pick up on. All right, it is well established in Georgia, but that last one wasn't well established in Georgia, but here, Cap E is well established in Georgia. It is well established in Georgia that, quote, where evidence of one crime would be admissible in the trial of the other crime, it cannot be said that the trial court abuses its discretion in denying a motion for severance. That's Woolfolk v. State, 282 Georgia, 139, 140 through 141. By the way, that's not the right dash. Citation omitted. Although this rule is most often recited in cases reviewing the lack of severance as to one defendant's multiple offenses, it has applied between co-defendants. See English v. State, and then we have a 1992 Georgia appellate case. Here, defendant Nichols and his co-defendants are each charged with a violation of the Georgia RICO Act. Now, by the way, just so y'all know, even though RICO is a common abbreviation, it's racketeering, criminal organization, racketeering, I forgot the full abbreviation. Even when you are citing something that is commonly known, like we know what RICO means, organized crime, they haven't said RICO yet, so they should have fully written out like what racketeering involved criminal organization. I believe that's RICO. They should have spelled the whole thing out before abbreviating it. So when I'm looking at citations from other jurisdictions, I'm looking at typos and mistakes in citations, and then I'm looking at basic legal writing errors like not spelling out RICO in the first instance. And then I'm also looking at this thing getting filed 3 minutes before the filing deadline. This just reeks of a disorganized district attorney's office, in my opinion, just from reading the filing. That's just my opinion. It doesn't mean that their argument is not good. The substance of it is not good. But it would tell me, if I were the defense counsel reading this and knowing, look, guys, I am like basically autistic. I'm undiagnosed autism. So I'm going to notice when your citations are off and when you're making mistakes and you're filing things at 3 minutes before the deadline. I mean, I'm going to notice that, and it's going to give me an insight into, hey, you're rushing to get these filings out. You're disorganized, or, it shows me that the defense has some momentum here when I'm seeing a lot of mistakes in the filings themselves. And that's just from a strategic standpoint. All right. Here, defendant Nichols and his co-defendants are each charged with a violation of the Georgia RICO Act, in which the state alleges they engaged in a conspiracy. Defendant Nichols's, and by the way, when you have something possessive ending in an S, don't use the apostrophe S, just the apostrophe right there. Defendant Nichols's separate actions and those of his co-defendants are alleged in the indictment as overt acts of that conspiracy. These are not just separate but related crimes, but the same crime, the RICO conspiracy charge. The evidence against each is evidence against all. A federal district court has provided a cogent summary of how the issue of severance of defendants works in a conspiracy case. And now we're going to see a big long citation from a federal case. Quote, a defendant does not suffer compelling prejudice sufficient to mandate a severance simply because much of the evidence at trial is applicable only to co-defendants. United States v. Oscar, Volume 877, Federal 3rd, 1270 at 1290. That's an 11th Circuit case. Nor does the fact by itself, quote, that a defendant only participated in one aspect of the conspiracy warrant severance. So here we see United States v. Andrews, another 11th Circuit case. We're in the 5th Circuit in Texas. I think Georgia might, in fact, be the 11th Circuit, although I don't have it memorized. But let's see, United States, U.S. State Circuit Courts of Appeal map. All right, I want to see which one Georgia is in. All right, so Georgia is in the 11th. As I said before, Texas is in the 5th. So when you see the 5th Circuit cited, that's going to be Texas, Louisiana, Mississippi. The 11th Circuit is Alabama, Georgia, and Florida. I don't have that memorized, by the way. So here we go. So they're citing 11th Circuit cases because that is the federal equivalent appellate. Again, not binding precedent on a Georgia state court, though. Moreover, in conspiracy cases, an argument of, quote, prejudicial spillover rarely supports a severance of co-defendants' trials because, in most cases, the evidence would be admissible even at a separate trial of the moving defendant. See United States v. Rosa, 11 Federal 3rd, 2nd Circuit. Where's the 2nd Circuit? 2nd Circuit is New York, New Hampshire, and Connecticut. So again, that's not even the Georgia Federal Circuit. I don't know. Once a defendant is connected with a conspiracy, he is responsible for acts of the conspiracy occurring before or after his association. Defendants' arguments ultimately boil down to general assertions that the evidence will be prejudicial absent a severance of the joint trial. But, quote, all incriminating evidence is inherently prejudicial. United States v. Collins, 697 Federal Appendix 652 at 653 11th Circuit 2017. So let's talk about that argument for a second. Defendants' arguments ultimately boil down to general assertions that the evidence will be prejudicial absent a severance of the joint trial. But, quote, all incriminating evidence is inherently prejudicial. The district attorney's office is referring to the Texas rule of evidence is 403. I don't know what the Georgia equivalent is, but in Texas it's more substantially more prejudicial than probative, and that's Rule 403, Texas rule of evidence. And the district attorney's office is not exactly making the right argument because yes, all incriminating evidence is inherently prejudicial, but that is not the test under the rules of evidence, at least not in Texas. The test is whether it is substantially more prejudicial than probative. Again, substantially more prejudicial than probative. Obviously, all evidence in criminal trials that tends to show your guilt or your culpability is going to be prejudicial against your interests. Against your interest of being incarcerated. That goes without saying, but that's not the real test. And so the district attorney's office here is just kind of bending a little bit, but that's not what the federal rules of evidence or the Texas rules of evidence say. And I believe that Georgia wholesale adopted the federal rules of evidence. So in Texas, it's 403. Again, that's not quite what the law is. It's just a slight sort of expansion, not exactly on point. Defendants have not shown evidence so prejudicial as to require a severance. Now, that's the right argument. Significantly, defendants do not explain why evidence of their co-defendants' involvement in the drug trafficking conspiracy would not be admissible against them in a separate trial. As set out above, the body of evidentiary law applicable to conspiracies, again, notice not applicable to Georgia conspiracies, but just applicable to conspiracies, which, is that persuasive? Sure, but it's not technically binding precedent in Georgia. As set out above, the body of evidentiary law applicable to conspiracies would likely preclude any such argument. Because the government contends that it expects to prove at trial that McIntyre and Mitchell each played a role, however small, in the conspiracy, evidence of the larger conspiracy at a joint trial does not satisfy defendants' burden to show compelling prejudice. Defendants' emphases on their comparatively minor roles in the drug trafficking conspiracy relative to their co-conspirators do not justify a severance. And so that was a case in the Middle District of Alabama from 2018. Okay, and so here we have a lot of citations to the 11th Circuit, which is the Georgia Federal Circuit. Again, that's not the Georgia State, but Georgia Federal Appellate Circuit. We also see a 5th Circuit citation, which is not the Georgia Federal Circuit. The 5th Circuit is Texas, Louisiana, and Mississippi. So again, that's not quite on point either. But that's fine. I mean, they're talking about evidence in conspiracies. And now we have the application. And you'll find oftentimes in modern legal writing, it's the application starts with here. Here, Defendant Nichols and his co-defendants' acts are evidence of the RICO conspiracy and are independently admissible against each of them, regardless whether tried at a joint or separate trial. Previous defendants have raised similar motions for severance in RICO prosecutions. Again, we have a typo there, RICO prosecutions. And the denial of their motions have been affirmed. And then here we have a Georgia precedent. Presumably, they don't have a parenthetical here, but presuming that these cases are on point with what their assertion is. There is no basis for severance in this case, and this honorable court should deny defendant Nichols' motion. Again, pretty standard, sort of rushed legal writing. There is no basis. Logically speaking, there is a basis, even if that basis is weak or has previously not worked. There still is a basis. So that's not exactly accurate, but of course this is advocacy, but you're not trying to logically and accurately render everything. But there is no basis is not completely accurate. There is a basis, even if that basis is weak or it is not likely to succeed, which I agree with the state, that motion is not likely to succeed. However, if there is a basis, there is in fact a basis. And in my opinion, even in your advocacy, you should be as accurate as possible. So there is no basis. No, there is some, but weak basis. And that would be more accurate. Conclusion. For the reasons stated above, the state respectfully moves the court to deny defendant Nichols' motion for a mistrial. And then this was submitted on the 26th day of June at the 3 minutes before the deadline. All right, so my thoughts on this. I've already given you my thoughts. Obviously, this motion, so I'm going to give you the legal argument, and then I'm going to give you what I think the outcome is. So first off, I think that the state is more likely than not going to prevail on this motion, and that the same evidence to prove up a conspiracy will likely be admissible as to one defendant and as to the other defendants. The reason why is a lot of people have the misguided perception that the U.S. Constitution and rules of evidence are limiting rules when they are in fact expansive rules. And the criminal justice system is designed to bring in more evidence than to exclude evidence. And so as a matter of default, you presume that some evidence is coming in. And that's just a part of our criminal justice system. I'm not saying I agree with that. I'm just telling you what it is. And so I think that more likely than not, any evidence that's going to come in against defendant Nichols is also going to come against defendant Williams, and it's also going to come against the other co-conspirators or alleged co-conspirators, the co-defendants, because the rules of evidence are rules of inclusion and not rules of exclusion. So I think that the state is likely to prevail on this motion. Now let me give you some of my legal analyses as I've been giving throughout this motion. Given the fact that this motion was filed 3 minutes before the deadline, given the fact that I'm seeing substantial mistakes in citations and I'm seeing substantial mistakes, I even see outright typos, and I'm seeing a lot of unpersuasive and non-binding precedents. So seeing cases from North Carolina, seeing cases from Louisiana, seeing cases from Texas, I'm seeing federal cases. What that indicates to me is that this motion was written in a rushed manner, and they were just looking for anything that they could find. What particularly stood out to me in this motion is this paragraph D. The temporary recess of the trial is not a basis for a mistrial. And then none of this, if I'm sitting as a Georgia judge and I'm looking at 3 citations to not Georgia cases and not even 11th Circuit cases, right? Meaning that I'm seeing cases from other states, that wouldn't persuade me at all. I'm not a judge, but I'm just saying that in my opinion, that wouldn't persuade me at all. What that indicates to me is that the district attorney's office, as to this point, the temporary recess of the trial is not a basis for mistrial. They couldn't find a Georgia case to back up that claim. Otherwise, they would have put in a Georgia case. So if there's one avenue, a narrow avenue by which the judge in this case could declare a mistrial based on this, the temporary recess, I think the district attorney's office, if they had Georgia precedent for this claim and they just negligently or just forgot to put in that Georgia precedent, that's on the district attorney's office, and that's just bad lawyering.
So anyways, and this citation, by the way, is terrible, forgetting the periods and then no pinpoint site and then not in.c. You expect a little bit better out of a district attorney's office, just my opinion. Maybe that's just my autism speaking. But if that seems to me, if I were a well-versed and well-educated judge and I were looking for a manner by which I could get this thing out on a mistrial, this temporary recess issue of a 1-month recess and the witnesses' memories, fading and the evidence becoming stale, I'd look at that and I'd say, oh, there's maybe my avenue for a mistrial. And by the way, you didn't cite anything from Georgia. I'm not seeing any Georgia precedent here. Seeing a whole lot of things that are not Georgia. So I think that might be the one avenue by which this motion could go forward. I will say, guys, that strategically, it obviously made sense for Defendant Nichols and his attorney to file this motion, but it's not a motion that is likely to succeed. It's not likely to succeed. Do I think it should succeed? Yeah, I think this case should be out on a mistrial for substantial procedural defects. However, I don't think that will happen, but again. All right, guys, so we're going to move on to the second motion here, and I know this is going to be a fairly long video, but hey, that's what I'm here for. By the way, guys, Ring On Law PLLC, if you were in the state of Texas and you've been arrested, don't talk to the cops, call me instead. All right, guys, so here we go. Fulton County Superior Court e-filed on Friday, July 26th at 11:22 p.m., so this one was filed 38 minutes before the deadline. Actually, I think that this motion to compel was actually due by Thursday, and then I think this was untimely filed. If I read Thugger Daily correctly, this was untimely filed. Okay, guys, so here we have State of Georgia v. Jeffrey Williams et al. So notice the last motion here was directed at Quamarvius Nichols et al. This is now Jeffrey Williams et al., who's a young thug. All right. Motion to compel defendants' compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed. Nice heading there. Pursuant to the official code of Georgia, annotated, section 1716.4, the state of Georgia moves this honorable court to compel each defendant currently on trial to comply with the reciprocal discovery demands imposed on defendants by OCGA section 1716.4. Further, the state moves this honorable court to exclude any evidence in possession of either defendant that has not been provided to the state at the time of this filing. In support of this motion, the state shows this honorable court as follows. So, guys, this is going to be a motion based on procedure. Now, I come from the world of civil litigation, which is heavily it's all about procedure. The criminal world is less involved with procedure and more involved with substance, but I'm pretty good at this procedure stuff typically because of my compulsion and autism. So anyways, I'm pretty good with procedure. All right, factual background. Defendants were indicted, and then we have footnote number 1 here. Footnote number 1 reads, the instant case is in fact a re-indictment of an earlier case in which the defendants opted into discovery as well. Defendants were indicted on the instant case August 5th, 2022. So instant case is a legal way of saying this case. The state began presentation of its case in chief on November 27th, 2023. So, guys, notice that the time between the indictment, and we're looking at over a year, and like, what is that, 15, 16 months from indictment to the state beginning its case in chief. That's a long time. That's a long time between your indictment and the state beginning its case. So if I were the state, I would, I'm not sure I'd be bragging about that. All right, more than 12 months prior to the beginning of the state's case in chief, each defendant opted into discovery under OCGA section 2416.4. Again, I'm not a Georgia licensed attorney, so these statutory citations I'm not familiar with. If it were like a Texas statute, I'd be more familiar. Okay, the state provided its round of discovery to the defendants on July 11, 2022, semicolon, and the state has continued to comply with its ongoing discovery obligations. All right, so first, a couple of writing commentary on this. Discovery is not a proper noun, so this really, I don't think that should be capitalized. Ongoing is one word. You don't need to hyphenate it. And then from another legal perspective, the state should not be bragging about its compliance with Brady and with Robertson. Was it Michael Robertson? Robertson evidence? Anyways, there's another case, but basically the state, as y'all are familiar with, the state has to give you its entire file under Brady and then also under the Michael Mortensen Act. So under the Michael Mortensen Act and then under Brady, the state has to give you, in a criminal case, its entire file. So it's not really something that the state should be bragging about. It should be presumed. But that's just my comment on that. During the course of this trial, Defendant Williams has repeatedly withheld from the state evidence in his possession even before the start of the trial until after the state began examining the witness through whom Defendant Williams sought to and was allowed to introduce. All right, here we have footnote number 2. Number 2, Defendant Williams withheld an audio recording of an interview with state witness Adrian Bean for 406 days until hours before his cross-examination of said witness. Defendant has thus far failed to provide an audio recording of his interview with state witness D'Angelo White, which D'Angelo White referenced during trial preparations with the state. And finally, Defendant Williams refused to disclose until after the state began direct examination of the current witness, Kenneth Copeland, jail calls of Kenneth Copeland that defendant held in his possession months in advance of the start of this trial. Okay. At the first known violation of Defendant Williams' discovery obligations, the state moved the court to compel the defendants, and particularly Defendant Williams, who's young thug, to comply with OCGA 2416-4. In the alternative, the state moved the court to exclude any evidence withheld from the state in violation of the statute. Defendant Williams argued that he has no duty to disclose any evidence to the state unless and until he begins nice typos there, case in chief or rebuttal. The trial court then denied the state's motion after noting that it appeared to the court defendant had no obligation to provide evidence to the state until after the conclusion of the state's case in chief. All right, guys, I'm going to take a quick break here. You're going to see a cut in the video, and we're going to start again with Cap 2, legal analysis. Welcome back, guys. We are here on Cap 2, legal analysis. And then we have italicized Cap A, which that's interesting. A defendant's refusal to timely disclose evidence in his possession, custody, or control, which he intends to introduce to both impeach a witness and to prove his innocence, constitutes a violation of defendant's reciprocal discovery obligations that warrants exclusion of the evidence at trial. And then we have, we're coming into some statutory analysis here. OCGA, Section 24416, requires that a defendant, all right, well, we don't have a colon here. We should have a colon here. Within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or as otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties or as ordered by the court to inspect and copy or photograph books, papers, documents, photographs, tangible objects, audio and visual tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, custody, or control of the defendant and which the defendant intends to introduce as evidence in the defense's case in chief or rebuttal at the trial. And then we have a citation here, OCGA section 1716-4B1. So I suppose that that's on point if defendant Jeffrey Williams had an audio tape that he was supposed to turn over and did not turn over. Quote, case in chief includes evidence offered by a defendant both as impeachment evidence and as substantive evidence of innocence. See United States v. Young, and then we have a Fourth Circuit. Again, we go back to our circuits. Notice that the Fourth Circuit is not Georgia. Just another thing that I wanted to mention. Okay, so we have a Fourth Circuit citation affirming a district court's curative action against the defense in a criminal case for failing to turn over a tape of a government's witness which the defense sought to introduce during cross-examination as both impeachment evidence and as substantive evidence of innocence. All right, so if you're
not an attorney out there and you're wondering what does impeachment evidence mean and what is evidence of innocence. All right, impeachment evidence is evidence that is used to impeach a witness. So let's say that you have John Doe, and John Doe is up on the stand, and John Doe says, I didn't commit that crime. I didn't shoot the victim. I was at my house at 3 p.m. in the afternoon on Saturday. And then let's say the state has a text message from John Doe putting John Doe at the scene of the crime at 3 p.m. So as soon as John Doe says, I was at 3 p.m., I was at my house at 3 p.m., I couldn't have been at the scene of the crime. And then let's say that the state has some evidence, like a text message from John Doe to his buddy, hey, I'm here at the scene of the crime at 3 p.m. You can use that evidence to impeach the witness. And basically, it's kind of the legal way of calling someone a liar. But it might not always be a lie, so to speak. I mean, it can also be just you have a witness who has a bad memory, or it might be an omission instead of an affirmative lie. It could be an omission. So impeachment is something that is used to contradict a witness's statement in order to impugn that impugn meaning damage that witness's credibility with the jury. And so the reason why strategically you might not want to turn over all your impeachment evidence, and usually impeachment evidence you don't have to turn it over, at least I know here in Texas in civil trials you don't. The reason why you don't have to necessarily turn over impeachment evidence is you are telegraphing to the other side, hey, I know your story is X, but I got all these text messages and these phone calls and audio recordings and YouTube videos that are just going to just rail you on cross-examination. So here, state, let me just go ahead and give you all of my impeachment evidence so you know exactly what we're thinking. And that's why you obviously don't want to turn over your impeachment evidence. All right. So let's say that Kenneth Copeland, the state's star witness, says something that the defense knows not to be true and has evidence is not true, or evidence tending to show that one of Kenneth Copeland's statement is not true. The obvious strategy would be not to turn that evidence over, and then when Kenneth Copeland makes a statement that the defense can impugn or impeach, wait until cross-examination and then admit it into evidence and impugn Kenneth Copeland's credibility with the jury. So again, then it goes to the jury, and if the jury's thinking the jury can't believe a single thing that Kenneth Copeland says, well then the whole case falls apart for the state. So for obvious reasons, you don't want to turn over your impeachment evidence, especially in a criminal case where your life, liberty, and property is at risk. Okay, so impeachment evidence is simply evidence which can be used to impeach the credibility of a witness. So as I said before, that's what it is. You could have rebuttal witnesses. So for example, you could have evidence can come in the form of both tangible evidence, and it can also come in the form of witness testimony. So you might have a witness, let's say Kenneth Copeland is a known liar, right? You might have your rebuttal witness come in and impugn Kenneth Copeland's credibility. Say that Kenneth Copeland makes a statement that they have a witness claims is false. So you're going to bring in that witness to impeach Kenneth Copeland. So you don't just have to bring in tangible evidence to impeach. You can also bring in rebuttal witnesses. Okay, and then here we go. What is substantive evidence of innocence? So remember that in a criminal trial, the standard is innocent unless, not until, innocent unless proven guilty. So an acquittal is not necessarily, hey, the jury thinks you didn't do it. It's just the state did not succeed in proving guilt beyond a reasonable doubt. Evidence of innocence is affirmative evidence. So, for example, the state claims that you were at the scene of the crime at 3 p.m., but you have a videotape of you sitting at your house at 3 p.m. That is evidence, actual evidence of innocence. And it goes further beyond just guilt beyond a reasonable doubt. That is evidence, affirmative evidence proving your innocence. So it's sort of a step above merely evidence tending to disprove something. It's affirmative evidence of innocence. Okay, and then so again, notice that affirming a district court's curative action against the defense in a criminal case for failing to turn over a tape of a government's witness, which the defense sought to introduce during cross-examination as both impeachment evidence and substantive evidence. You don't want to do that as defense counsel. You don't want to have to turn over all of your impeachment evidence. You've got an audio tape showing that the state's star witness is not credible on this item or the next item or many items. You don't want to turn that over to the state. You don't want to give that to the state. All right, and here we go. A defendant has a duty to disclose prior to trial and an ongoing duty to timely disclose any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. And then we see C-ID. So, again, well, here we go. This is the Southern District of Georgia, which is a federal case, not a Georgia state case, a federal case. So when it says C-ID, it's citing back to United States v. Waddell, which is citing back to a Southern District of Georgia, not a Georgia state case. So, again, I'm seeing another theme in this motion that I saw in the last theme, which is citing a lot of cases that are not Georgia state cases. Citing a federal case is not the same thing as citing a state case. It's not the same jurisdiction. The federal government and the states are not the same jurisdictions. It's persuasive, sure. Defendant Williams has repeatedly refused to comply. By the way, notice that a defendant has a duty, and then they bold and underline that one, but then timely disclose is bolded but not underlined. So you're using two different methods to show emphasis, which is just a little bit sloppy in the same sentence. And by the way, like proper Blue Book form for emphasis is italics. The state therefore moves this honorable court to compel each defendant in this case to immediately comply with the reciprocal discovery demands of 1716-4, that should have a section symbol, and disclose to the state any evidence in the defendant's possession, custody, or control that reasonably may be offered both to impeach a witness and to prove the defendant's innocence. Well, the state is actually... All right, so my autism is going to speak for a moment, but I'm going to speak about logic for a second. And in legal analysis, logic is very important. So the state, I think that maybe like one of the young district attorneys may have wrote this. I don't know that for certain, but there's some mistakes here that I'm going to point out. So I want you to read this sentence carefully. The state therefore moves this honorable court, demands of 1617-4, and disclose to the state any evidence in the defendant's possession, custody, or control that may reasonably offered both to impeach a witness and to prove the defendant's innocence. Notice that the state said both to impeach a witness and to prove the defendant's innocence. It didn't say either to impeach a witness or to prove the state, which is the correct way to put this. In legal writing, or is always inclusive. So what does that mean? If I say either A or B, I mean either A by itself or B by itself or both A and B together. But if I say A and B, the only combination that is logical is A and B. Does that make sense? So or is inclusive. It's not exclusive. And means that it has to be both, but not one or the other. So here we say that may be reasonably offered both to impeach a witness and to prove the defendant's innocence. If you had evidence that was, in other words, the state is making the wrong argument. The state wants to make the most inclusive argument as possible, meaning may be offered either to impeach a witness or to prove the defendant's innocence. The reason why is because there's just, logically speaking, an argument here that, okay, if I have evidence that is only to prove the defendant's innocence or only to impeach a witness, I don't have to turn that over. Again, that's just some legal logic that comes in, and if you're sitting for the bar exam or the LSAT, that's something that you need to learn. Either or, inclusive or. So a little bit of mistake there. The state further moves this honorable court to exclude any evidence that any defendant has refused to disclose in a timely manner. Okay, Cap B. Although exclusion of evidence is an extreme remedy, repeated and intentional violations of reciprocal discovery obligations warrant exclusion of the evidence at trial. Why is it an extraordinary remedy? You are not. So let's go back to the U.S. Constitution. Let's look at the Sixth Amendment. In all criminal prosecutions, the accused shall have compulsory process for obtaining witnesses in his favor, have the right to be confronted with the witnesses against him, and then let's go back to the 14th Amendment. So this is all in due process. So what I'm showing you here is that's 10th Amendment, 12th, 14th Amendment. Nor shall any state deprive any person of life, liberty, or process without due process of law. Okay, so we look at the Sixth Amendment and we look at the 14th Amendment to the U.S. Constitution, which are binding on the states. The reason why it's an extraordinary remedy is even if I'm withholding evidence, and let's say that does violate a statute, and let's say I withheld evidence intentionally and knowingly violating Georgia statute 1716-4. But if that evidence materially would have proven my innocence, and the state, because of some procedural mechanism, is preventing me from introducing that evidence. So let's say, for example, I've got evidence that absolutely proves my innocence of the crime with which I have been charged, and I knowingly and intentionally withhold that from the state in violation of like this Georgia statute, and I am convicted and I'm put in prison, and my life and my liberty is deprived of me. Your right to constitutional due process, at least in theory, should trump a procedural mechanism like discovery, even knowingly and willingly violating a state statute, because the U.S. Constitution is the supreme law of the land. So that's why it's an extraordinary remedy, and even the state is acknowledging that. And I think that if this motion to compel is granted, you're looking at further appeals. If this evidence is actual evidence that could be used to impeach, so this audio recording, and I haven't listened to this audio recording, I just know it's a piece of evidence that tends to impeach Kenneth Copeland or another state witness, or I know that it's, as described here, it's evidence tending to prove innocence. If that evidence is excluded because of a Georgia state statute, you're looking at an appeal. Not saying that appeal is going to succeed, but you are looking at an appeal, because potentially if that evidence is enough to sway a jury, or to sway a court of innocence, then your constitutional right should trump or should go over a state statute. So if this evidence is excluded, you're almost certainly looking at an appeal. I don't know if that appeal would be granted, but I'm giving you the basis for that appeal. The state recognizes that exclusion of evidence is an extreme remedy, which is true, and the state does not move the court to exclude every late piece of evidence that the defense may tender at trial, which is what the state should be arguing. Indeed, the state did not move to exclude the extremely untimely evidence introduced by Defendant Williams until it became apparent that Defendant Williams was intentionally flouting his reciprocal discovery obligations. The state only asks that the court guarantee a fair trial for all parties and mandate that defendants adhere to their continuing reciprocal discovery obligations or face exclusion of evidence intentionally withheld in violation of those continuing obligations to disclose. The state here, let me comment on this argument. The state is making a fairness argument. And does the state have an interest in prosecuting crime and removing convicted criminals from the streets? Yes. But in my opinion, that the state's interest does not overcome or trump your individual constitutional rights to due process. In other words, your 6th and your 14th Amendment rights to process. So the state here is making an argument that all parties are, in fairness, the state's not looking at going to prison for life. Defendant Williams is looking at going to prison for life. It's just on the face of it, it's not if were I a judge and I'm looking at the interest between the state, I'm looking at the interest between adhering to justice and removing criminals from the street, whatever the state's interest, and then I'm looking at this guy's interest at being in custody for the remainder of his life. I'm going to go with the defendant every time and say that interest is more compelling than the state's nominal interest of removing criminals from the street. I don't think that those two interests are balanced. So this is sort of an argument that both sides are playing in an equal playing field here, which is something that, of course, the state is going to argue. But that's, guys, you have to realize that's not true. That's not true. Yes, the state has an interest in prosecuting crime. I am not pro-crime. Okay? Let's be clear here. I'm a criminal defense attorney. I'm not pro-crime. But the state here making an argument that, oh, well, all things are in fairness and equal playing field. No, not equal playing field. One is the freaking state and one is an individual. So it's not a good argument, in my opinion. Whenever the state makes an argument in fairness between the parties, this is not civil litigation. You're not looking at two companies arguing over a breach of contract. You're looking at a guy going to prison for the remainder of his life, and you're looking at the state. So just that fairness argument does not ring a bell with me. Maybe that's just the criminal defense attorney in me. 3, conclusion. And then notice conclusion. Yeah, conclusion is still flush. So somebody, by the way, I just wanted to mention this. Somebody wrote this motion who didn't write this motion. So someone else in the office wrote this motion, because notice that, what the hell is this Roman cap I doing at the outside of the page margin? So look at Roman cap 2 is outside the page margin. Roman 3 is outside the page margin. And then look here, Roman 1 is inside the page margin. Roman 2 is going to be inside the page margin as well. So I have a strong feeling that someone else actually wrote this brief than the other one. For the reasons stated above, the court should compel each and every defendant in this case to comply with his reciprocal discovery obligations under 1716-4, and the court should exclude, with all caps, any evidence tendered by the defense that has been intentionally withheld and not disclosed in a timely manner. So in order for this motion, even just by the logic of this motion, you must prove that it is withheld intentionally and not disclosed in a timely manner, both of those. So again, I just think that's a little bit amateurish. But what's really amateurish are these Romans. What are these Romans doing outside the page margin? How does that even happen? So, and notice that this was filed 38 minutes before 12 a.m. This one was filed 3 minutes before the deadline. So the one that was filed 38 minutes before the deadline had greater formatting errors than the one that was filed 3 minutes before the deadline. So someone can explain that to me. I don't know, but I just think that's interesting. My overall thoughts on this motion is I don't even like this statute. If that is the manner in which that statute is written, I think that prejudices the defendant too much, and I would argue for a change in policy that the defendant is under a statutory obligation. It just seems wrong to me. Why would the defendant be under a statutory obligation to turn over all of his impeachment evidence so that the state has a greater probability of putting you in prison for the rest of your life? So that doesn't jive with me. If that is the way in which this statute is to be interpreted, which it sounds a lot like a civil statute, I don't like it. I don't like it. I mean, you should be able to withhold some of your impeachment or rebuttal evidence because that might be all you have at trial. So I don't like the fact that if that is the way that Georgia statute is written, I would argue for a change in policy if I'm understanding it correctly. I just think it violates your rights. And then the other thing I don't like is the state only asks that the court guarantee a fair trial for all parties. That argument is predicated upon the state and these private individuals having the same playing field, which is not true. One is the state, which is never going to run out of money. It has a tax base, and it has a bunch of salaried attorneys that all they do all day is prosecute people. And then the other one that have no vested interest in the outcome of this litigation. And then number 2, you have an individual defendant or a number of individual defendants who are looking at life in prison, who have limited resources. Granted, these are wealthy defendants, but even were that not the case, the state is still immensely more powerful than private individuals. And so I don't like an argument on fairness when you're the state. Maybe that's just my anti-state bias talking, but that is how I feel about that. Again, those are my opinions, but not, that's not gospel truth, folks. That's just one man's opinion. And then, obviously, guys, I've talked about this in my last, and the court should exclude. There is no reason to have all caps bolded and underlined and to scream in your motion. It is you can add emphasis. I just think that this thing is amateurish. I mean, you've got Romans outside the page margins. How the hell that even happened, I don't know. You've got different emphasis. One is bolded and underlined. The other one is only bolded. And then this is you've got citations to the Fourth Circuit, why are there citations to the Fourth Circuit in a Georgia state court? I don't understand that. And then making a fairness argument when you're the state definitely doesn't make a lot of sense to me. But that's just my bias speaking. It's kind of like reading these state motions, and this is something that I talked about on Friday. It's like they're throwing up their hands and just judge. We're the state. No one cares for the state. You're the freaking state. You're the state. You're not going to get sympathy when you're the state. I'm sorry, just my feelings on that. All right, we have a third motion here, and let's see if their Romans are actually in the page margin. All right, so we have state's response in opposition to defendant STILLWELL's motion for reconsideration. And guys, this was e-filed at 11:22, so this was e-filed 38 minutes before the deadline. And here our Romans are within the page margins, unlike this one where the Romans are not within the page margins. This one, at least the Romans are within the page margins. Okay, Roman 1, Introduction. Chief Judge Glanville's ruling that statements made by young Slime Life YSL gang member Demikian Garlington to fellow YSL gang member Kenneth Copeland are admissible co-conspirator statements under OCGA Section 24.8801 D2E is proper and need not be reconsidered. That's a good sentence. I like that. That's a strong sentence. This section symbol should be one space from the numbers there. But otherwise, it's a fine statement. On September 30th, 2022, defendant Stillwell filed a motion in limine requesting a hearing and objecting to the admission of these co-conspirator statements as, quote, inadmissible hearsay. Ultimately, and that should be a comma there, ultimately, Chief Judge Glanville held a hearing and denied defendant Stillwell's motion. And then we have footnote number 1. Footnote number 1 reads, State agrees with defendant Stillwell that the record does not reveal any written order encapsulating the court's oral ruling preliminarily admitting the statements subject to proper foundation at trial. Only after recusal, on July 23, 2024, did defendant Stillwell file this motion to reconsider. Okay, so what? Therefore, this court should deny, in all caps, this thinly veiled attempt at de facto judge shopping because the court's prior ruling was in accordance with OCGA Section 24.8801 D2E. However, if the court is inclined to consider defendant Stillwell's motion, the motion should be denied. Okay. Let's see. I forgot a sentence there. There is no legally salient intervening change in statute or jurisprudence warranting reconsideration. Thinly veiled attempt at de facto judge shopping. Maybe it's just the civil litigator in me and just the polite. Look, I'll be honest. I'm in a jurisdiction here in Nueces County, Texas, where, for the most part, everyone has been very nice and considerate and pretty polite. Okay. I don't practice in a big city. I practice in a fairly small town in a fairly small county in Texas. And I just, something like thinly veiled attempt at de facto judge shopping. That is assuming that someone is trying to rig or corrupt the system. It's not
making the assumption that your opponent is filing something in good faith, which you should assume that your opponent is filing something in good faith. So I don't like that thinly veiled attempt at de facto judge shopping. That's a little harsh. It's a little like, okay. I'm not saying it's wrong. I'm not saying it's not persuasive and it's not advocacy on the state's behalf. I don't like it. Okay. Roman 2, factual background. The defendants are all charged under count 1 with violation of the Racketeer Influenced and Corrupt Organizations and then RICO Act for their participation in the conspiracy. By the way, I want to see if this is signed Adrian. I'm skipping to the end here. I want to see if this is signed Adrian Love. Okay, guys, so in case y'all don't know this, in a big DA's office like Atlanta, Georgia, even though that is signed Adrian S. Love, Adrian L. Love, more likely than not, didn't actually type this, and I can tell you how. Notice that this cap S signature, by the way, it should be a small s. Notice that that is unitalicized, okay, and that is different from this signature, and that is different from this that signature, and this signature here are that's Adobe Acrobat. That's an Adobe e-signature, and then that's just a typed cap S Adrienne L. Love. So unless Adrienne signs her name, remarkably differently, one using an Adobe e-sign and the other one just typing it out S, she didn't actually type these. Someone at the office that's not her typed it, and then she reviewed it, which I'm not saying that that's wrong or something, but the public might not. You see something that's signed by Adrienne Love, you might presume that she actually wrote that, but she didn't actually write that, more likely than not. And then notice here that this is something else that you can notice. The defendants are all charged under count 1 with violation of the Racketeer Influenced and Corrupt Organizations Act. So notice that this person, whoever actually typed this, which is probably not Adrienne Love, actually wrote out in the first instance Racketeer Influence and Corrupt Organizations, RICO. And then if I go back here to the first motion where RICO is mentioned, let's see, Control F, RICO. Can I find that? It's not OCR'd? Okay, this is not OCR'd, but in the first motion that we read here, response and opposition to Defendant Nichols' motion for mistrial, notice that the first time that RICO... There we go. So notice that violation of the Georgia RICO Act. Notice that whoever actually wrote this first motion did not spell out RICO, whereas in the third motion, someone else wrote this, actually spelled out RICO for the first time. And then notice that this person is probably an older attorney, and I can tell you why whoever actually wrote this is probably older, because when you see the quotation marks here and it's not just parentheses, that tends to be what older attorneys did, okay? So more likely than not, you're looking at like a middle-aged attorney that wrote this motion. Neither of these people are probably Adrienne Love that actually typed these out, but if you're not trained in this, you wouldn't know that. So I'm just telling you, you can notice stylistic differences. Attorneys tend to get a style in which they write, and you can tell when it's them and it's not them. And then there are manners of writing that are newer, and there are more archaic manners of writing. And you can tell when someone who's just out of law school, so for example, if you see here, comma, that way of introducing an application statement is something that you learn in law school, and they only recently began teaching that. In the past, it used to be in the present case, in the instant case, in the case at bar, at the case at bar. So there used to be different ways of introducing that, and now everybody's just taught to say here, comma. And so it's sort of a telltale giveaway that you have a younger attorney writing something when it's here, comma. It's not like a guaranteed thing, but that is the way that they teach it now, whereas in the past it was in the present case, in the case at bar, in the case before the court. So there's just little things that you can notice. Why does this matter? You're in a high-stakes litigation trial.
okay, and you're looking for every little piece of information that you can possibly find. You're trying to keep your client out of jail. You're trying to get your client out of jail. You're trying to get your client on a mistrial, trying to get him acquitted, or you're trying to overturn something on appeal. You need to know your opponent. You need to know your opponent. You need to know how committed to the case your opponent is. You should know the name, the age, the everything about your opponent, and to know whether your opponent is how difficult your opponent is going to make your client's life and your life. And so when I see something, for example, that says here, comma, that tells me more likely than not a younger attorney like myself wrote that. And a younger attorney is more likely to be more liberal than conservative. And a younger attorney that writes here like that, this is probably a female that wrote this, and a female at the district attorney's office in Atlanta County, Georgia, is probably Democrat, probably more criminal justice reform minded than a conservative. And so that's information that you can use on a plea bargain. And all of that I can tell by here, comma. And then there's autism. Okay, so anyways, that's exactly how I am. And I'm sorry I wasted all that time in the video, but it's true. It's true, guys. I mean, criminal defense attorneys and federal prosecutors and civil litigators will, if they're like me, and I'm just compulsive, but my brain is wired different. But these are the things that you notice. You just do. So I wanted to give you all some thought on that. And then also, this all cap denied, it's something that you do when you presume that the judge is just scanning over or glancing at your argument. So typically, right, someone like Judge Whitaker in Fulton County, Georgia, is probably dealing with literally thousands of misdemeanors and felonies all the time, and probably doesn't even fully read all these motions. In this case, she's probably reading all of the motions word for word, because it's a big case, and she's not going to want to get this one overturned on appeal. So I don't think it's necessary to do this should deny all caps. I don't think it's personally good. Anyways, the other thing is that, notice there is no legally salient intervening change, M- in statute or jurisprudence, M- warranting reconsideration. So someone older, an older attorney that's probably had some experience in civil litigation, wrote this motion. Neither of these were written by Adrian Love. I can almost guarantee you that. But even if I'm wrong, maybe I'm wrong, but I believe that two different people wrote this. And notice, this person has a substantially different writing style than this person. You don't see this person using an M-. This person is writing with an M-. And then this is a higher dialect or higher diction than this motion. So I think that if you're looking at which motions the state is more concerned about, the state more likely than not assigned its higher level or more experienced attorneys to state's response in opposition to defendant STILLWELL'S motion for reconsideration. I think that they probably assigned in the office, they probably assigned a more experienced litigator to this motion, and they assigned the newbie to this motion. Just my opinion. Okay. All right. Continuing. As alleged in the indictment, the objectives of the YSL gang conspiracy include, there should be a comma there, but are not limited to, quote, begin quote, preserving, protecting, and enhancing the reputation. There should be a comma there. In legal writing, you keep your Oxford comma. So a little bit of sloppiness there, but it should be preserving, protecting, comma, and enhancing the reputation, comma, power, comma, and territory of the enterprise through acts of racketeering activity, including murder, assault. This doesn't need to be bolded. Any judge that's sitting, you know what the gang activity includes. I don't like that, including murder, assault, in all bold. That's, of course, gang activity includes murder, assault, drug trafficking. I mean, that's part of the definition. So it doesn't need to be bolded and emphasized, but with bold, the judge knows what gang activity is going to involve. The average person understands that gang activity typically involves murder and assault. So I don't like it. threats of violence and maintaining armed individuals ready and willing to preserve, protect. This almost sounds like the police. Preserve, protect. Sounds almost like your local police department. I'm kidding. Preserve, protect, and enhance the reputation, power, and territory. We're just missing Oxford commas here. Power and territory for the enterprise through the use of violence. Okay. Count 2, murder, as well as overt acts 16, that should be an N dash, 16 through 20, not a hyphen, that should be an N dash, 16 through 20 of count 1, pertain to the January 10, 2015, there should be a comma there, gang-related drive-by shooting murder of Mr. Donovan Thomas Jr. at approximately 7:22, here we have footnote 4, admitted State Exhibit 2Y is the CAD report, County Appraisal District? I'm not sure about that. Report that documents the initial 911 call date and time. At 330 McDaniel Street, there should be a comma there, Atlanta, Fulton County of Georgia. Additionally, defendant Stillwell and his fellow YSL associate co-defendants, including co-defendant Garlington, have been indicted for multiple violations of Georgia's Street Gang Terrorism and Prevention Act. If that's going to be cited again, that should be abbreviated. On June 10, 2015, and see here, this attorney included the comma, but it's not up here. Mr. Copeland was interviewed at Atlanta Police Department, APD headquarters. You could actually have two different attorneys writing the same motion, because notice Atlanta Police Department here is abbreviated without quotations, whereas RICO is abbreviated with quotations, and typically one attorney is going to maintain the same style. So you could have multiple attorneys here working on the same response or same brief, is what could happen here. Headquarters by Homicide Detective Thorpe, Gang Detective Dennis, and Gang Detective Gaither. During this interview, Mr. Copeland stated that YSL member Garlington informed him that defendant Stillwell and other co-defendant YSL associates Justin Cobb, Demise McMullen, and DeMonte Kendrick were responsible for Mr. Thomas's murder. Also, Mr. Copeland discusses other YSL criminal gang activity that Mr. Garlington shared with him. M dash. That should really be a colon, but M dash, all right. For example, missing a comma. Discussions about the April 26, 2015, no comma there. No, that comma's fine there. Shooting of Dwayne Carter's tour bus. All right, so I'm going to reread that back. Also, Mr. Copeland discusses other YSL criminal gang activity that Mr. Garlington shared with him. That sounds like hearsay. For example, discussions, that sounds like hearsay within hearsay, but okay, hearsay. Mr. Copeland stated that on January 10, 2015, sometime shortly after the murder, why is murder capitalized here? Is the murder a proper noun? I don't think so. He met Garlington at a McDonald's parking lot located at 150 Cleveland Avenue, forgetting a period, southwest Atlanta, Georgia. Mr. Copeland saw multiple YSL gang members arrive at the McDonald's, to include defendants Garlington, McMullen, Williams, Stillwell, Kendricks, and Kelvin Treadwell. Garlington entered Mr. Copeland's car and immediately told him that, quote, they just killed Nut. And so Nut is actually a proper name, and that should be capitalized. Mr. Copeland then followed Treadwell up to defendant Williams' Midtown Atlanta apartment with Garlington and McMullen in his car. Upon arrival, Mr. Copeland stated that Garlington provided him with additional details of the murder. Garlington stated that he was riding in a car along with defendant Williams and a female, and they spotted Mr. Thomas outside the barbershop at 330 McDaniel Street. Garlington, defendant Williams, and the female switched cars and got into a Pontiac. McMullen, defendant Stillwell, Kendricks, and Justin Doo-Wop Cobb were in a rented Infiniti, I have an Infiniti, I love Infinitis, that committed the drive-by shooting that killed Mr. Thomas. Garlington told Mr. Copeland that Stillwell fired an AK-47 and McMullen fired a handgun while Kendricks drove the vehicle. And then 6. Admitted State Exhibit 284Y reveals 7.62 and .45 caliber shell casings were found and collected at the murder scene. A few days before the murder, Mr. Copeland stated he was with defendant Williams when he rented the Infiniti from a rental facility at the Atlanta airport. This same Infiniti was used in the murder. Evidence admitted at trial proved that defendant Williams rented an Infiniti Q50, yikes, on January 7, 2015, and the vehicle was returned on January 11, 2015, so at least he returns his vehicles. Testimony at trial revealed that Mr. Thomas was a high-ranking rival Inglewood family blood gang member to the YSL criminal street gang. The week before Mr. Thomas was murdered, Mr. Copeland was physically assaulted at Club Crucial by Mr. Thomas's half-brother, Kelvin Shellkel Watts. Then we have footnote number 8 here. Also through testimony of APD gang detectives at trial, a documented Inglewood family blood gang member. Okay. In the early morning hours after the murder, multiple YSL gang members, to include Mr. Copeland, Mr. Williams, Mr. McMullen, the names go on, fled to Miami, Florida. After the YSL street gang members returned to Atlanta, there should be a comma there, Georgia, there were a number of retaliatory shootings between the two rival gangs. Okay, guys, quick pause before I get to Cap 3, Roman 3. All right, guys, welcome back, and we're continuing. Roman 3, argument and citation of authority. Defendant Stillwell's argument ignores Cap A. Roman 3, Cap A. Cap A should be indented. It's the next heading. Statements made in furtherance of the conspiracy are not hearsay. For those of you that are about to take the bar exam or getting into law school, hearsay is an out-of-court statement which comes in for the truth of the matter asserted. Again, hearsay is an out-of-court statement which comes in for the truth of the matter asserted. Okay. Defendant Stillwell's argument ignores numerous facts and controlling legal principles. Most significantly, Defendant Stillwell fails to recognize that this is a gang and criminal enterprise prosecution, an emphasis on gang and criminal enterprise prosecution. As such, the underlying conspiracy in question pertains not only to the murder of Mr. Thomas, but more broadly to the activities of the YSL criminal street gang. Therefore, the conspiracy in question continues today. YSL continues to exist and operate as a criminal street gang, and in Garlington's statements, better described as party admissions, to Mr. Copeland were in furtherance of that conspiracy. Pursuant to OCGA Section 24.8801D2, quote, admissions shall not be excluded by the hearsay rule. An admission is not only defined as, quote, a party's own statement, but it is also defined as a statement made by a fellow co-conspirator during the course of a conspiracy. OCGA Section 24.801D2E, Rule 801D2E mandates that hearsay prescriptions do not apply to, quote, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy, including a statement made during the concealment phase of the conspiracy. To admit evidence under Rule 801D2E, the Georgia Supreme Court has held, quote, the state is required to show by a preponderance of the evidence, meaning a civil standard, more likely than not, that a conspiracy existed, typo. The conspiracy included the declarant and the defendant against whom the statement is offered, and the statement was made during the course and in furtherance of the conspiracy. And then we have Plain 1, criminal conspiracy. The YSL criminal street gang is the criminal conspiracy in this case, as alleged in Count 1 and as the evidence at trial has revealed. Here, all of the defendants, to include Defendant Stillwell, are involved in the larger criminal conspiracy of the YSL street gang. When, quote, a defendant is charged under the Gang Act with committing a crime in furtherance of the purposes of a criminal street gang, he may be part of two conspiracies, the immediate conspiracy to commit the crime and the, quote, larger criminal conspiracy, end quote, to participate in the gang. And then we have a citation here to footnote 13, and that's Henderson v. State. Okay. A criminal street gang is a, quote, general conspiracy among several individuals to commit crimes. 14. Although in Kemp, the murder had already been committed when the co-conspirator statement was made in the larger conspiracy, and the germane one, the Gangster Disciples criminal street gang was still an ongoing criminal conspiracy. The court explained, the fact that the defendants accomplished the specific acts charged, the charged murder, did not end their involvement
or association with the gangster disciples, nor did the criminal street gang's purpose necessarily end with those crimes. Similarly, in Shavers v. State, the Georgia Supreme Court held that a declarant's statements were admissible under OCGA Section 24.801 D2E, which is the hearsay exception, where, quote, the evidence showed that as fellow members of the Rollin' Twenties gang, the defendant and the hearsay declarant who made statements implicating the defendant were part of a larger criminal conspiracy. Georgia courts draw their interpretation of this code section from the federal courts, which have reached the same conclusions on co-conspirator hearsay as the Georgia Supreme Court did in Kemp and Shavers. And then we have a long footnote 18 here. So have a look at this. Therefore, because YSL, both on January 10, 2015 and today, is an ongoing criminal conspiracy, statements made by co-defendants to other co-conspirators are admissible if they were made in furtherance of the YSL criminal street gang. So this kind of makes you question if the state is saying that YSL, this is something that Cat Williams talked about, if the state argues that YSL is a street gang and that street gang's activities continue to go on. Remember that the state has put forward an argument, at least in the alternative, to the best of my knowledge. The state has put forward an argument that the YSL street gang was a hybrid gang, meaning a gang of a small number of individuals for small tasks, and that's what the newest nomenclature of a hybrid gang is. And this motion, or this response in opposition to Defendant Stillwell's motion, would cut against the argument that the state is making that YSL is a hybrid street gang, because it presumably, if YSL were a hybrid street gang and only had between 6 and 12 members, then all of said members would have been indicted or given immunity in this prosecution. Okay? So in other words, stating that the YSL street gang is a, quote, ongoing criminal conspiracy cuts against the state's prior argument that YSL is a hybrid street gang. Now, in addition to that, it would also beg the question, if YSL is in fact a street gang, then why are they not all indicted? Why have the other co-conspirators not been indicted on the same charges? Now, we know why Kenneth Copeland, or we know why witnesses offered immunity in order to provide inculpating testimony. We know why they're indicted or unindicted co-conspirators. But if we have these other individuals out there about whom the state knows and is merely choosing not to indict, so we have unindicted co-conspirators, then what, is the state just on its hands? Are the sheriff's deputies are the police just not doing anything? Is there just negligence going on here? Is there something from these unindicted co-conspirators that would tend to prove the current defendant's innocence? So why is this ongoing criminal conspiracy just allowed to be ongoing? The state knows about it. And it would also go against the hybrid. So there's two things that I'm getting at here. Number one, the state's argument here would go against the hybrid gang theory that was postulated earlier, but it would also beg the question of, why are there unindicted co-conspirators to begin with? Is law enforcement just sitting on its hands? Okay. Number two, statements made in furtherance. Both the 11th Circuit, so remember the 11th Circuit is the Georgia Federal Circuit. All right, so both the 11th Circuit and Georgia courts apply, quote, liberal standard in determining whether a statement is in furtherance of conspiracy. And that's right, guys. Remember that the rules of evidence are rules of inclusion, not exclusion. To be admissible under this code section, a co-conspirator's, should be a possessive there, a co-conspirator admission need not be necessary to complete the conspiracy, but must only further the interests of the conspiracy in some way, which is broadening language. Okay. Statements between co-conspirators which provide reassurance, serve to maintain trust and cohesiveness among them, meaning the co-conspirators, or inform each other of the current status of the conspiracy, further the ends of the conspiracy.
Okay, and here we have a citation, footnote 21. See also United States v. Flores, holding that a co-defendant's statement providing details about a murder to another gang member was admissible as a co-conspirator statement because it was made to gain respect and constituted statements in furtherance of the conspiracy because they were designed to, quote, foster cohesiveness within the gang. That's very broad language, right? So just merely reassuring someone else about the conspiracy is enough to be a hearsay exception. You don't actually have to have a statement made to the made by the declarant against whom to the person against whom enforcement is sought. You don't actually have to have that be in furtherance of some crime in a concrete way. I'll be right back, guys. Okay, guys, and we're continuing. Furthermore, narratives of past events, however, are admissible under Rule 801 if they serve some present purpose in the conspiracy. So again, we go on about how the rules of evidence are inclusive rules and not exclusive ones. 3, statements are admissible where the state can meet the requirements of Rule 801, D2E. Any co-conspirator statements made in furtherance of the YSL criminal conspiracy are admissible as non-hearsay statements. Notably, the state need not prove the existence of this conspiracy prior to the admission of the statements at trial. Chief Judge Glanville has stated, and the state has introduced evidence at trial that has proven to a preponderance that YSL is and was on January 10, 2015, a criminal street gang. Application and analysis. Currently, the state has already provided evidence and testimony to prove by a preponderance of the evidence that YSL is a criminal street gang, and both Kenneth Copeland and Demikian Garlington were members of said conspiracy on January 10, 2015. The YSL criminal street gang is an ongoing criminal enterprise and conspiracy, as charged in Count 1 of the indictment. Both Garlington, the declarant, and Stillwell, the defendants against whom the statement is offered, are members of that criminal street gang, and thus the ongoing conspiracy of that criminal street gang include both of them. Finally, the statement was made in the course of the conspiracy because, as in Kemp, the statement can be interpreted as fostering cohesiveness with another gang member and as proving information to a fellow co-conspirator of the criminal street gang's activity. And that is the gang-motivated murder of Thomas and the gang-motivated shooting of Dwayne Little Wayne Carter. Within hours of the murder of Mr. Thomas, Mr. Copeland, along with other YSL gang members, fled the city of Atlanta and headed to Miami, Florida. Should be a comma there. Multiple retaliatory shootings occurred between Inglewood family Bloods and YSL street gang members in direct result of this murder. Given the recent physical altercation between Mr. Copeland and Kelvin Watts, multiple public threats were made against Mr. Copeland. It was imperative for the sake of the YSL street gang that Mr. Copeland become aware of the circumstances of the murder so the YSL street gang could be on alert for retaliation. Therefore, as the Georgia Supreme Court held in Kemp and the 11th Circuit held in Flores, the statements in this case are admissible under Rule 801 D2E. The court should thus deny all caps, underlined, and bolded Stillwell's motion to reconsider this correctly ruled decision. Okay, and so that concludes the argument that this statement should come in as a statement in furtherance of a conspiracy, which, if you wanted my legal analysis on it, I generally agree with the state's argument. Not saying it's right, just, and fair. I'm just saying I generally would agree with that argument. Cap B. Alternatively, the evidence is also admissible as a declaration against interest. Mr. Garlington's statement as to Mr. Copeland is also admissible as a declaration against interest pursuant to OCGA Section 24804B3, and then that's going to be Rule 804B3. This code section permits the admission of a hearsay statement, quote, which a reasonable person in the declarant's position would have made only if the person believed it to be true because when made, it was so contrary to the declarant's propriety or pecuniary interest or had so great a tendency to invalidate a claim by the declarant against another or to expose the declarant to civil or criminal liability, semicolon, so some of this is not chopped off, that should be 3 dots, and supported by corroborating circumstances that clearly indicate the trustworthiness of the statement,
if it is offered in a criminal case as a statement that tends to expose the declarant to criminal liability. To be admissible under Rule 804b3, a statement must satisfy three requirements. 1. The declarant must be unavailable. 2. The statement so far tends to subject the declarant being the one who said the statement, to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true. And number 3, the statement is corroborated by circumstances clearly indicating its trustworthiness. The United States, so guys, notice that in order for it to come in under 804b3, all three of these must be the case. The declarant must be, the one who actually made the statement must be unavailable. The statement is so against self-interest, and the statement is corroborated by circumstances clearly indicating its trustworthiness. So you need all three of those things. Otherwise, it's excluded. The United States Supreme Court has previously explained the logic behind this rule. Rule 804b3 is founded on the common sense notion that reasonable people, even reasonable people who are not especially honest, tend not to make self-inculpatory statements unless they believe them to be true. Further, courts have held that the mere fact that the recipient of the information was a confidant of the declarant does not rule out admissibility of a statement as against interest. Okay, Cap A, Garlington's statement was a declaration against interest. Mr. Garlington's statement to Mr. Copeland admitting his knowledge about the murder, other crimes, and its perpetrators, quote, his fellow gang members, constituted a declaration against interest. First, Mr. Garlington is charged in this case with Stillwell. Assuming Garlington does not testify, he is, quote, unavailable for purposes of Rule 804b3. So that's the first prong, and that's true. As to the second prong of the analysis, Garlington's statement is self-inculpatory, meaning self-incriminating. Garlington had significant information about the gang-motivated crime, and Garlington is a member of the same criminal conspiracy as those he named as the murderers and as the shooters in the incident involving Dwayne Carter. Therefore, quote, given the context of Garlington's relationship with Stillwell and the other YSL associates who murdered Thomas, Garlington had no reason to lie about the murder or shooting. I don't know if it's entirely accurate to say he had no reason to lie. Logically, you might have many reasons to lie. Finally, as to the third required prong of the analysis, courts have found that self-inculpatory statements are sufficiently corroborated where the evidence presented at trial supports the veracity of the out-of-court statement and where the declarant makes the statement to someone with whom he shares a close relationship. Okay, so you would need two things to prove this prong. You need the evidence presented at trial basically tells the judge more likely than not it's a veracious, meaning truthful statement, and also the declarant needs to make that statement to someone with whom he shares a close relationship. Okay, so Mr. Copeland and Garlington are members of YSL with shared gang affiliations and have shared a close relationship for a number of years. The idea being that when Garlington made the statement to Copeland that he wouldn't lie to Copeland, with shared gang affiliations have shared a close relationship, Mr. Copeland testified that out of all the YSL gang members, he is the closest to Demikion Garlington and Shannon Stillwell. These conversations were not to law enforcement, but amongst close gang members and friends. Interesting that we're using the British amongst in this filing. The context of the statements thus demonstrate their self-inculpatory nature and corroboration as required under Rule 804b3. And then we have footnote 33. So see U.S. Infrastructure, it's a federal case. Whether the declarant statement is against the declarant's penal interest can only be answered in light of all the surrounding circumstances. Okay? Therefore, this statement is not only admissible as a co-conspirator admission, but it is also admissible as a statement against interest. This court should thus deny, in all caps, bolded and underlined, Stillwell's motion to exclude this statement and hold that this statement and any related statements are admissible upon the state establishing the proper foundation at trial. Conclusion. Mr. Garlington's statement to Mr. Copeland was correctly held to be admissible in this case by Chief Judge Glanville and should not be reconsidered. The Georgia Rules of Evidence, as well as their federal counterparts, specifically provide multiple means for Garlington's statements to be admitted through Mr. Copeland's testimony. This evidence is admissible not only as a co-conspirator statement, but also as a declaration against interest. Contrary to Stillwell's claims, Georgia's Evidence Code, that's not good English, has a specific statutory provision mandating that a co-conspirator statement, like Garlington's statement to Copeland, is not inadmissible hearsay. Therefore, there is a clear means for the state to admit this statement. This court should deny, all caps bolded underlined, Stillwell's motions to reconsider Chief Judge Glanville's prior ruling admitting these co-conspirator statements. Okay, and then it was served to all the defendants. Okay, guys, so my brief thoughts on this. I think that the state has a pretty strong argument here, and because the rules of evidence are rules of inclusion, not exclusion, I would tend to agree with the state's argument. Not saying it's right, just, fair, or whatever. I tend to think that the state is going to prevail on admitting the statement from, Garlington to Copeland. I would tend to agree that is going to be admitted under either of those hearsay exceptions. I tend to agree with that. Okay, guys, let's go back to Thugger Daily. And see if we have any other items on Thugger Daily. Okay, we've got some more. Got some more stuff that I should make a video on, but not in this video, guys. I'm going to. Well, should I do it in this video or the next video? Okay. I'm going to go in the next video. So, guys, thank you for joining me. This has been Law by Reese with another video. Please make sure to like, comment, subscribe, and use the donation links in the description box below.